Good afternoon, Kalisperisas. I think we should get started. And so good afternoon, Kalisperisas. It's a very great pleasure to welcome everyone to our webinar on getting out of charter parties. For those that are not familiar with me or the team, I'm Clarke. I'm the Head of Claims and Regional Director of the club's Greek office. We have a team of 15 people handling P&I and FD&D claims for our members who are based in Greece, Cyprus and the Middle East. And our details can of course be found on the club's website. Ordinarily, we're fortunate to have many of our members close by to the office and in Greater Athens, and they're able to join us for our ongoing seminar programme at the office in Piraeus, where we have a large seminar room. Indeed, this seminar I discussed with Dimitris some time ago, and it was one that we were going to run in the office last March, but unfortunately had to be put on ice due to COVID. Sadly, that COVID seems to be stuck with us for longer than we anticipated, so a webinar is the next best format. The only pity for us really is that we can't have the opportunity to enjoy a glass of wine and a catch-up afterwards. But turning to the topic, getting out of charter parties, this is one that affects most of our members, whether they're owners or charterers. And getting out of the charter parties is often a result of the change in the market. From an FD&D perspective, we are very often at our busiest when the market makes an adjustment. And if the rates go up, the owners want out of the longer term fixture, but the charterers want to keep it. And conversely, if the rates dip, the charterers want to take advantage of them. So the immediate reaction for either party is to turn to the charter and see what can be done. The other scenarios that we see are where charterers aren't paying the hire, leaving owners with options such as withdrawal, suspension of service, and looking carefully at the anti-technicality clauses. These aspects can be quite tricky because the devil is very much in the detail. And finally, we occasionally see a charterer who just wants to redeliver early, and that's that. What can owners do about it? Should they just acknowledge they cannot get blood out of a stone, accept the breach, refix and claim damages? Or are there some other options out there for them? Well, I'm very pleased that these issues are going to be explored by Dimitris and Anassis, who's a partner at Penningtons, Manches, and Evelyn Komaki, who's an associate at the firm, and their Piraeus office. Their office is actually next door to ours, and we can even wave at them through the windows. They'll be going through some of the legal issues and the charter party points, and then we'll be having some practical case study scenarios, and I'll join you later for one of those. But I'll leave Dimitris to make his own introductions, particularly as the company name has changed to Penningtons from when Thomas Cooper merged. We're really happy throughout the webinar to try and answer any questions, but as webinars are a little different in their structure from a normal personal presence seminar, we'd ask that you type your questions or any contributions into the Q&A box. We'll do our best to try and keep up with these as we go along, but otherwise we'll look at them at the end and address further questions or any queries at the end. And particularly if there are any common themes, we'll group those together. So thank you for joining us. And now over to Dimitris.
Thank you very much, Ian. Good afternoon all, or good evening, depending on the time zone you're in. My name is Dimitris Anassis. As Ian said, I'm a partner at Penningtons Manches Cooper, and we're very grateful to the West for hosting this webinar today and for having us and inviting us to co-present. If I could have the next slide, please. Right, so this is what we're going to be going through today. And I'm joined by my colleague, Evelyn Komaki, who's an associate with Penningtons Manches Cooper. And if I could have the next slide, you'll all be very happy to note that this webinar is not about COVID-19 for a change. I'm sure that everybody is by now completely zoomed out or Skyped out or teamed out in relation to this topic. And no doubt people's attentions may be to the recent, just 4 days ago, Supreme Court judgment on business interruption. But we're not going to be going through this today, although we're always happy to discuss such topics. If we can have the next slide, please. So this is a brief breakdown of what we're going to be discussing today. I'm going to go through a very quick introduction as to who we are and what we do. And then we thought we're going to very quickly go through the law on suspension of service, withdrawal, and termination, followed by some case studies, including some real cases that we went through, and hopefully some not very difficult questions at the end. So moving on, if I can have the next slide, great. So we are Penningtons, Manches, Cooper. This is a name that may not necessarily be familiar to people in shipping. This is because this is the result of a merger in 2019 of a number of firms that you can see up on the slide. Penningtons, that traces its roots back to 1729, Manches going back to the mid-1930s, and Thomas Cooper, which is where I came from, tracing its roots back to 1825. So we have a complete offering in terms of legal services. And Thomas Cooper came as the marine trade and energy arm to Pennington's Manches offering. We have over 500 years of combined history, and we maintain our international offices in Madrid, Paris, Piraeus, Singapore, amongst others, as well as important affiliations on best buddy type connections with international law firms through multi-law and the European Legal Network. So why did we decide to cover this topic? As Ian said, there can be a number of reasons why a party may want to get out of a charter party. And they could be financial reasons, it could be viability, depending on the market, and a number of other reasons. So we thought we would cover this topic and discuss the detail of the matter and the practical aspects of it, so as to ensure that a party can get out of a charter party lawfully, and also look at the repercussions of them not doing so. So I'm going to hand over to Evelyn now, and she is going to take us through the law on suspension of service and withdrawal. And I'll be back very shortly. Thank you.
So thank you, Dimitri. I hope you can all hear me. We're starting with suspension of service. So the question is, what options can owners have in case they want to get out of the charter party, either in a permanent or in a temporary manner? So the first weapon is suspension of service, or in other words, withholding performance under the charter party. This is an immediate but temporary remedy. It's a contractual right, and several performers provide for such a right. For example, the NYPE 93 form, the BP Time 3 form, or the Supply Time 9089. So unless expressly allowed under the charter party, an owner cannot enforce a suspension of service. Unless something different is stipulated in the charter party, no notice of intention to suspend service is required to be served on a charterer generally. During the period of suspension, a hire continues to accrue, and of course that is the whole essence of this weapon. And depending on the wording of the charter party, the charterer would normally have to indemnify the owner for the consequences that may arise because of the suspension. For example, liabilities to third parties that an owner may incur, and so on. So if we had to recap on suspension, then we could say that this weapon is in effect the leverage of financial pressure that an owner may have upon a non-compliant charterer. So if I can have the next slide, please. So let's move on to a second, more draconian remedy that an owner may have, which is, of course, withdrawal. This is a permanent remedy as opposed to suspension, and that in effect means that the charter party is brought to an end. Like suspension, withdrawal is a contractual right which is provided from certain performers in the market, like the NYP 9046 or the Shell Time 4. So unless again it is provided for under the charter party, the owners cannot exercise it. For an owner to be able to exercise such a right, hire must be due, and even a small amount of hire due entitles the owner to withdraw. It is very important, and it is usually where many mistakes occur, that any anti-technicality provisions that are present in the charter party are complied with. For example, there may be a grace period that is allowed for a charterer of some hours or days or banking days to be allowed to owners to charters, sorry, to cure the breach which has happened before withdrawal is allowed. Most withdrawal clauses would also require a notice of withdrawal to be served on the charterer before withdrawal is enforced. Such a notice must be clear, it must be unconditional and unambiguous, and it should be given within a reasonable time after the default occurred. So, of course, what is reasonable will depend on the circumstances of the case, but we have some guidance from case law in relation to what is reasonable. So we know that, for example, a notice served after 4 to 5 days from default of a charterer is a notice that was held to have been served within reasonable time. Late payment of hire does not automatically cure a charterer's breach of non-payment of hire in a timely manner. So, in other words, the right to withdraw is not defeated by a late payment of a missing hire. Now, it may be that an owner wants to accept payment of the late hire, as they are entitled to do, but also withdraw for market reasons. In that case, given the factually complex issues that may arise on whether an owner has waived either by words or by conduct their right to withdraw the vessel by, for example, accepting a late payment of hire without reserving their rights in terms of their default, we advise owners generally that they reserve their rights in terms of charterer's breach of non-payment of hire, even if they want to accept a late payment. So if I can have the next slide, please. Now, the next question is, what about the case where a charterer deducts some amount from hire, which he claims that are owner's responsibility, and at the same time, the owner is uncertain whether these deductions are lawful, in which case he's not entitled to withdraw the vessel. So the first step in such a case is to consider the nature of the deductions. Are these deductions permitted? In terms of deductions of hires, the general rule is that the charterers must pay the hire in full. However, there are certain circumstances where deductions from hire are permitted. Of course, the first case is where there is an express right under the charter party which allows deduction from hire. We can have the right to deduct, for example, the value of bunkers from last hire payment, or periods of off hire, or, for example, time lost due to reductions of speed. Another case where deductions from hire could be found to be allowed are when these are affected by a way of equitable set-off. We will look into equitable set-off more closely in a moment. The next step is, how much time does an owner have to consider these deductions as affected by the charterer? Again, some reasonable time will be afforded to an owner to consider these deductions and decide whether he should accept them or not. And this interrelates with a reasonable time that is allowed to an owner to serve a notice of withdrawal as a result. The next question is, how much can a charterer deduct lawfully? So can a charterer deduct whatever amount he wants? The answer to that question is found in the Nunfree case, a 1978 case, where it was established that the charterers generally are not in default if, in respect of a permitted deduction, they withhold any sum which they claim in good faith and they assess on a reasonable basis. So as long as the charterer deducts in good faith and on reasonable grounds, such deductions are lawful. And for example, if a tribunal finds later that the amount of such deduction was excessive, but that was not due to bad faith shown by the charterer, then the owner will only be entitled to a return of the excess amount. And in that case, they may be found in breach if they had withdrawn on the basis of a permitted deduction. So that needs a bit of attention, of careful attention by the owners. So next slide, please. So in order to conclude this area of deductions from hire, we thought we should expand a bit more on the doctrine of equitable set-off. So say for where there is an express right, as we said, under the charter party, which allows deduction from hire, a charterer may invoke the doctrine of equitable set-off to justify certain deductions from hire. So the relevant test in terms of permitted deductions by way of equitable set-off is whether there was a breach by the owners that deprived the charterer from the use of the ship or which has prejudiced the charterer in the use of the ship. So of course, the test is there, and okay, we said the test, but we thought it would be more useful to refer to some real life instances where the courts or the tribunals have or have not allowed such deductions in practice. So equitable set-off was allowed in the event of a breach of a speed and performance warranty by the owners, or where there was some loss of time which resulted from a master's refusal to enter the port, or where there was a failure by the owner to make the whole cargo space of the vessel available for the charterer to load a full cargo. On the other hand, there are some cases where it was found that no right to equitable set-off arises. For example, that was in cases of claims for cargo shortage or damage, or there was a failure by the master to keep proper logs, or, for example, where charters purported to deduct a bunker's cancellation fee. Of course, all these are specific instances, and everything will depend on the facts of the case, and everything will depend on the construction of the charter party as a whole. So if I can have the next slide, please. So now going back to withdrawal, the question is, what are the remedies that an owner has if he decides to withdraw the vessel? So first of all, the owner will only be entitled to hire up to the date of withdrawal. And of course, he will also be entitled to any other amounts which are due at the time of withdrawal, rather than damages for any losses that he may have suffered for the rest of the charter party period, which are the so-called loss of bargain damages, unless they have contracted on a NYPE 2015 pro forma charter party, which expressly provides in clause 11C for a contractual entitlement to damages for loss of bargain damages following withdrawal. Also, the owner may claim damages for loss of bargain for the remainder of the charter party as a result of withdrawal if the non-payment by the charterer was also a repudiatory breach of the charter party. That means that it goes to the root of the contract, or where there was an intention by the charterer no longer to be bound by the charter party, and Dimitris will expand on that in a moment. So if we have a repudiatory breach, the owner will be entitled to damages also for the remainder of the charter party period. The matters become a bit more complicated when, of course, we have cargo on board the vessel. And if the owner withdraws, then he at the same time, he's under parallel duties under the contract of carriage to deliver the cargo to the destination. For that service, owner will probably also be entitled to claim remuneration. So generally, opportunities and risks. To conclude, we could say that owners will generally have a commercial incentive to withdraw the vessel from charter service if there is a rising market and they want to charter the vessel at a higher rate. But at the same time, owners would be advised to carefully consider whether they can withdraw, because they may be found in the future to have unlawfully withdrawn, either because charters had the right, for example, to deduct certain amounts from hire, or because the withdrawal mechanics have not been properly complied with. So over to you, Dimitris, on termination.
Thank you very much, Evelyn. If I could have the next slide, please. Right, so we saw a relatively draconian measure, which is withdrawal. But the question arises, is there anything more draconian? And the answer is termination. So what and how would a party be entitled to terminate? There's two basic ways. The first one would be there's a contractual provision allowing the party to terminate, although we don't often see that in charter parties, but mostly in shipbuilding contracts. The other way is for the guilty party to have committed a repudiatory breach, so as to allow the innocent party to terminate and seek damages. So how can we define the repudiatory breach? Thankfully, the court defined a repudiatory breach in the Afovos case in 1983 as such. So a party will be in repudiatory breach of a charter if it shows an intention no longer to be bound by the charter, or an inability to perform such that the threatened non-performance would deprive the innocent party of substantially the whole benefit of the charter. There's nothing uncontroversial about that, or is there? But before we go there, in terms of a notice, because one should always get their notices right, there's no magic to a notice of termination, provided that a party is making it clear that they're terminating the contract. If I can have the next slide, please. There's two important principles that one needs to keep in mind when considering a repudiatory breach and or terminating. The first one is the minimum performance rule, so that when a party decides to terminate, they need to know what the maximum or minimum performance required of the guilty party is, and it is trite law under English law that it is the minimum performance that the breach of the guilty party needs to be compared against. The next principle is the available market, and this is no doubt a familiar principle to all of you. And the main question here is if the vessel can be rechartered for the balance of the charter party to be terminated on generally similar or equivalent terms to that repudiated charter party, except for the hire. And there's a reason for that. The reason is that the courts in shipping have applied Section 50, subsection 3 of the Sale of Goods Act, that provides that the measure of loss of a failed sale is the difference between the price of the goods, the market price of the goods at the time of the breach, as against the contract price. So in shipping, the courts have in English law transposed that, and they have basically decided that a reasonable mitigation of the innocent party would be to have a measure of loss, which would be the difference between the market rate less the charter party high rate for the remainder of the period of the terminated charter party. Now, things get a bit more complicated if an available market does not exist, because then there's no standard against which one can compare the performance of the contract against, so as to bring the innocent party to the position as if the contract had been performed. So what becomes of great importance in cases where there is no available market is the concept of mitigation. So an innocent party needs to have mitigated, and what actually happens is important, because the measure of loss in cases where there is no available market is the difference between the actual and the projected income. So like in the Kildare case, which is a seminal case in this matter, the exercise that the court would effect basically would be to see what the actual position of the innocent party is as against what the position would have been had the charter party been performed. But there are some accepted deductions that need to be made. For example, deductions for commissions that the owner would have in any event paid, deductions for off-hire that the vessel, based on her previous history of off-hires, would have potentially, in the course of the charter party, have sustained. And there are also, in particular in the Kildare, a 1.5% deduction was accepted for accelerated recovery, because the innocent party would immediately receive an amount through damages, as opposed to having to wait through the course of the charter party to receive it. And a 1.5% deduction was also accepted in the Kildare for catastrophic contingencies, i.e. to take into account the risk of the vessel being lost in the course of the charter party. So, having considered these two principles, if I can have the next slide, please. We are looking at, we thought we would consider some examples that can potentially give rise to termination. The first one is the failure to pay hire. And there is no doubt at the moment in English law that a failure to pay hire is an innominate term, although some doubt was cast by Mr. Justice Floor in 2013 in the case of the Astra, where he found, albeit arguably in obiter, that failure to pay one hire only constituted a breach of condition, entitling the owner to terminate. Now, the position was put beyond any doubt in a case that we were in fact involved in 2013 before the Court of Appeal, the Grand China Logistics versus Par Shipping, where it was stated that failure to pay hire is an innominate term, is a breach of innominate term. So, as any breach of an innominate term, this sounds in damages, unless the breach is so serious so as to go to the root of the contract. Now, there is a rule of thumb that everybody is aware of. If a charter owes 3 hires or more, then an owner is probably entitled to terminate, and that remains true. Why? Because failure to pay 3 hires is interpreted as an intention no longer to be bound by the charter party. And this is why it's always a good idea, if a charter is not performing, for an owner to ask, simply by sending a message saying, do you intend to perform? Do you intend to perform? And a failure to respond to these messages could be seen as evincing an intention not to be bound anymore. Of course, English law is all about freedom of contract, and there is absolutely nothing preventing the parties agreeing contractual terms, making payment of hire a condition. like in the Mahakam case in 2011, where the charter parties stated that punctual payment of hire was of the essence, and that was acceptable wording to show that the payment of hire was a condition of the contract. So, if we move on to the next slide, an area where we get very interesting questions is early and late redelivery. Right. So before one can decide if a vessel has been redelivered late or early, what do they need to know? They need to know the minimum or the maximum duration of the charter party, respectively. These days, almost invariably, charter parties include ranges of duration, and very often we have the use of the word about. And about is often, again, given a value, so 15 days, 20 days, a month. It's important to note that in the event that there is no reference to about, then one needs to be reasonable. So there is case law whereby a 4 to 6 month, a charter party of 4 to 6 months duration where the words about were used, the leeway that the court allowed was 5 days only. So in the case of early redelivery, which is something that Ian Clarke will shortly be talking about in more detail, as he was involved in the seminal case, an early redelivery constitutes a repudiatory breach. So an owner can either accept the repudiatory breach and terminate, or they can potentially try to refuse to have the vessel redelivered to them early. And the concept of them having a legitimate business interest to accept or reject redelivery has been outed and seems to be the law at the moment. The measure of loss is the usual Elena D'Amico measure of loss. So it will be the difference between the charter party rate and the market rate. And going to the late redelivery aspect of things, now contrary to an early redelivery that constitutes a repudiatory breach, a late redelivery is a breach of an innominate term, which means that sorry, I seem to have lost. Sorry, can everybody hear me? Right, apologies for that. So, as I was saying, contrary to an early redelivery that constitutes a repudiatory breach, a late redelivery is a breach of an innominate term, which means that it sounds in damages, unless it goes to the root of the contract. So the measure of loss for a late redelivery is the market rate at the time for the excess period. So late redeliveries give rise to very interesting and quite often complex questions of law. And these relate most of the time to other losses that an innocent party is seeking to recover. I don't want to spend too much time because talking about this can take an age. But basically, one, in considering other types of losses, needs to go back to the basic principles of damages under English law. So a loss needs to be established, there needs to be causation between the loss and the breach alleged. The innocent party needs to have mitigated, and also the loss sustained must not be either unforeseeable or too remote. The seminal cases of the Achilles and the Sylvia spring to mind. And I thought it was important to so to speak, go off script a little and discuss very quickly the differences between these two. The Achilles was a very special case, and it was overturned here and there until it got to the House of Lords, as it then was, in 2008. What happened in the Achilles was a vessel was redelivered late under a charter party, so a subsequent fixture was lost. And the House of Lords decided to, so to speak, close the floodgates and find that the innocent party could not recover damages for this pure financial loss. and that the loss was limited to the usual standard of the difference between the charter party rate and the market rate for the overrun. So basically, what the House of Lords did was to to make this situation part of the second limb of the Hadley and Baxendale test in relation to indirect losses or consequential losses, where actual knowledge or of special circumstances outside the ordinary course of things was required. Now, things seem to have been brought back to normality with the Sylvia case, albeit a High Court case, a first instance case, where Mr. Justice Hamblin, as he then was, he's now been promoted to the Supreme Court, found that a sub-charter party that had been lost due to the owner's breach under the head charter party was recoverable in terms of the profit. And he basically applied Lord Reed's opinion in the Heron 2, a 1969 case, where he found that a loss of the type that would have been in the contemplation of the parties at the time they entered it in the contract as being not unlikely to occur was basically that. He equated the knowledge that a sub-charter party could go wrong if something under the head charter party went wrong. And that I think makes sense. Over to the next slide, please. Apologies for going off script. Another interesting area where we get some very interesting and again, often complex questions is notices of re-delivery. First of all, one thing needs to be made clear, and it's this, that a re-delivery is a question of fact, and it is not conditional to a proper or contractual notice having been given. Having said that, if a proper and contractual notice has not been given, an owner may be entitled to damages. And there's a very interesting case of Mr. Justice Cook, although it's almost impenetrable in terms of reading it, where he clarified the law at a first instance level, but it hasn't been challenged, to my knowledge, since then. And there's nothing controversial about the facts. What happened in this case was that a charter party required an approximate notice of 20, 15, 10, and 7 days prior to redelivery, and then definite notices of 5, 3, 2, and 1 day. And the reason for this, as you all know, is that an owner needs time to market the vessel and find the next employment. So they need a bit of time. So it is more than reasonable, if they don't get this time, to be entitled to damages. But what is the measure of loss? The questions that Mr. Justice Cook posed were these. And what happened in this case was that the charters gave a 20-day approximate notice of redelivery, but then redelivered the vessel just 6 days later. So the question was the charter's breach a breach for redelivering only 6 days after giving a 20-day approximate notice, so that charters should be liable for a delay of 14 days for the overrun, or was charter's breach one in relation to not giving the required notice approximately 20 days prior to the actual date of redelivery? The problem with this latter, with the second question, is that it would be very difficult to quantify owner's loss. So if, for example, one goes 20 days prior to the actual notice of redelivery, it would be very difficult to quantify what would the market have been, how the vessel would have been marketed, and so on. So Mr. Justice Cook opted for the first question. So basically, the charterers should be liable for a 12-day overrun, and the reason why it's 12 and not 14 was because the judge gave a 2-day leeway to the 20-day approximate notice due to the approximate nature of the notice. So it's all very interesting. I'm always happy to discuss these complicated questions because very often a decision needs to be made on the spot, and we're always happy to assist. If I could have the next slide, please. So talking about the opportunities and the risks involved in termination, certainly one needs to always look at the contract because it can well be the case that contractual terms deal with the situation in hand. And as Evelyn also said, in terms of withdrawing, one needs to allow sufficient time before termination to consider their options, and they are entitled to a reasonable time. As I said earlier, it's always a good idea to seek confirmation from the other side of their intention to perform. That can be invaluable in terms of evidence years down the line. And continuing to reserve one's position is always a good idea. And of course, the best idea of them all is to involve lawyers to assist. Right, over to the next slide. So if one were to consider not necessarily pros and cons of withdrawal and termination, but the different nature of the two, as Ian said at the beginning, and as Evelyn also said later on, in a falling or indeed no market, it would make sense for an owner to keep the charter party going. Of course, that doesn't apply in a rising market where at the first available opportunity, an owner would want to withdraw and get the benefit of the rising market. Of course, there may not be an available market, and that's an important consideration, and that's why an owner needs to always take that into account and speak to the chartering department and generally to brokers. Of course, the existence of cargo on board can make things a little more complicated. On the one hand, owners can effect a lien on the cargo in the event they are entitled to, and we can look at that slightly a bit later on. As Evelyn said, if there's a withdrawal or a termination and there's cargo on board, an owner may have bailee duties, and there is clear case law that they're entitled the cost, that they're entitled to remuneration for taking care of the cargo and for taking it to destination. And as always, enforcement considerations are very important because a charter can disappear and an owner or the vessel can disappear overnight, as we have seen happen. So that was a quick run through the law that we hope you found useful. We thought we would then have 3 case studies, and I'm going to hand over to Ian Clarke to talk us through his case, the Aquafaith, and then we can pick it up later with our next case studies. Ian, over to you.
Thank you. It's somewhat hard to believe that this is almost 10 years ago. It feels like yesterday since I was dealing with this initial inquiry. In this case, it's one called the Aquafaith, which is a reported case. And the members who were owners had chartered to a company called Shigang, who were based in Hong Kong. And that company was guaranteed by a parent company in China. It was a really long-term time charter, 59 to 61 months. And within the terms, it said there was a warranty there would be no redelivery before month 59, which was going to be the 10th of November 2011. Now, on the 6th of July, the charterers said that they were going to redeliver after the current voyage, and then they did so in the 9th of August in China. The vessel was empty at that point, and it was quite clear that there was an anticipatory repudiatory breach by the charterers. And the question that then came to me from our owner members was, well, do we have to accept this? And as I said at the start, one of the things that comes into consideration is very often, can you get blood out of a stone? Do you just accept it, get on with mitigation, and then you bring your claim back against the charterers and hope that you can get security, or else perhaps, like in this instance, pursue the guarantors under the charter? Well, this is an interesting question, particularly because the rates that the members were going to be able to achieve if they accepted this breach and drew the charter to an end were absolutely on the floor at the time. And indeed, to refix the vessel or to get a decent enough fixture, they were going to have to do a very costly repositioning from China, perhaps through to South America. So that was going to be a detriment that they were not keen to embrace if they could help it. So we looked at this a bit further, and we took some advice from Tim Hill QC, and eventually he was quite adamant that actually, no, you don't have to accept this. The vessel really is at the whim and the availability for the charterers until month 59. And if they choose not to use it, that's their choice. The vessel is just pending and waiting for orders. And of course, the charterers didn't agree with that. And ultimately, this went to a very quick arbitration. Now, the charterers won in that arbitration, and we appealed, and we got leave to appeal to the High Court. Now, there was some discussion about a case called White and Carter. I won't go into that, but it's there on the slide if you ever want to have a look back through it, or indeed the Aquafaith case itself. But the High Court, Mr. Justice Cook, said that the arbitrator had erred in law and hire didn't depend on charterers performing, and it was therefore reasonable to keep the charter party alive. So owners were right to refuse the delivery and were entitled to hire. Now, of course, this dragged on rather, and one of our means of trying to draw this to a conclusion was the fact that hire was due every 14 days, and when it hadn't been paid, we pursued a winding up order in Hong Kong. That's quite a powerful tool, actually, and is quite unique to some of the Anglo-Saxon legal and common law jurisdictions. This was important because, A, we got paid the hire, and secondly, it seemed that the Chinese parent guarantor company were still keen to keep Shigang alive. They did so fortunately throughout the whole period of the term that we're talking about, and our member's case was successful. But not long afterwards, the parent company decided that Shigang in Hong Kong needed to fold. And I know of other owners who had similar difficulties, but were simply unable to enforce other than trying to go against the guarantor in China. So the question really was very case specific here. And it did relate to having very low charter rates and very low spot rates, where owners were put in a position where they said, we don't really want to have to accept this breach. Ultimately, they did, and we got the case resolved. But it's certainly quite a curious one on its own facts, but it's still very good law and is something to bear in mind in the event that you're having to look at a charterer wanting to redeliver early. Now to the second case study, which is back to you, Dimitris.
Thanks, Ian. Right, so going to our second case study, we thought we would take an actual case that we had 3 or 4 years ago and present it to you. This case seems at first glance to be a plain vanilla case, but trust me, it's not. So this related to a time trip charter party, 35 days, to carry an iron ore cargo from Iran to China. Now, the background to this is that at the time, Iran was suffering from a lot of sanctions, particularly from the US. And although the owners did their proper vetting in terms of the cargo, the charters, and so on, they forgot to vet their own hull and machinery insurers. And they found out shortly after entering into the charter party and shortly before the laycan period started that one of the H&M's shareholders was American. So the vessel could not call at an Iranian port. They decided to try to negotiate. They moved to the laycan a few times, but in the end it became obvious that they could not perform. So what did the charterers do? They terminated, as they would. And as you would expect, in trying to mitigate for their loss, and so that the business under the intended charter party could be performed, they took on a substitute vessel. But they did not go to the market to find an alternative vessel. They in fact chose another vessel they had chartered in a few weeks prior to entering to the charter party at an extortionate rate. So, so far so good, and proceedings commenced, and what we represented the owners, and what we thought was, right, we're pretty much done on liability. Let's try to fight quantum. So in disclosure and in dealing with the case, we discovered that the sub-charter party that the charter has disclosed contained a very interesting clause. And according to this clause, the parties had the ability to switch the bills of lading, creating new bills of lading, showing that the origin of the cargo was not an Iranian port, but Iskenderun, a Turkish port. So clearly, this was fraud. So the owners, our position, soon became that this fraud, this option to issue bills of lading that in fact were issued in this case, and the charters disclosed them, we said that it tainted the entire business. And so whether the owners had been in breach of the charter, but it was not relevant, because if they had not been in breach and if we had performed the contract, we would have been involved in charter's fraud. And we invoked the ancient principle of exturpi causa non oritur actio, so the prevention principle. The Latin saying says that there can be no cause of action arising out of an illegal act. We argued that the charters could not benefit from their illegality. And also, we argued in terms of the quantum. Even if we were wrong on the matter of liability, we argued that the charters taking on another chartered-in vessel of theirs did not constitute proper mitigation, and in any event, the rate of this vessel did not reflect the available market. So two questions came before the tribunal. The first one was if the charter party and the sub-charter party could be performed independently. And I wish we had the chance. I don't know if you can. People that think that that the owners were right, if they could raise their hand electronically, if it's easy, just to see how many think that the owners were right, that the charter's illegality tainted the entire business. I can see no one. That's probably. Right. Okay. Well, anyway, it just so happens that the tribunal found that the charters were right, and the tribunal found that it was possible for the charter party and the sub-charter party to be performed independently. So the owner's clear repudiatory breach should not be the owner should not be entitled to breach the charter party and walk away. That would be a windfall. Of course, at the same time, we're very disappointed because we would have expected a London tribunal to discourage this type of behavior, i.e. fraud. On the question of an available market, the tribunal heard expert evidence, and it decided that the vessel chartered in by the charters did reflect the available market, because then there was in fact no other vessel around. So that was an actual case that we had, and it shows that no case is the same as the last one, and there can always be things that someone can clench on and try to argue. We also think that a different tribunal on a different day would have found that the fraud did taint the entire business. So over to the next case study. Now, we thought, having done a previous case, we would construct a theoretical scenario and we're always open to your input in terms of the solutions and suggestions that may be relevant here. So let's take a time-chartered laden vessel, and the vessel is approaching the port of X. Doesn't matter what X is, but let's call it an exotic jurisdiction. And there's a dispute, there's a genuine dispute between the owners and the charterers in terms of deductions of hire that the charters have effected. Now, we could make things easy and say that the charters had the right, contractually or by way of an equitable set-off, to make these deductions, or that the owners were entitled to suspend services, either contractually or through a charter party like NYP 93. But we won't do that because we make things easy. So there's a dispute between the owners and the charterers. And the owners are considering effecting a lien on the cargo and not entering the port of discharge until and unless they're paid. But of course, as in most situations, it will obviously be appreciated that the owners have obligations as vis-a-vis the cargo receivers under the contract of carriage, as evidenced by the bills of lading. So what should the owners do? What are the risks and what are the options available to them? We think this is quite a realistic scenario, and it happens all the time, and it frequently leads to standoffs and impasses where it's always a game about who's going to blink first. But of course, the owners need to keep in mind that in effecting a lien over the cargo, they're facing a breach potentially under the contract of carriage. So the charter should be warned that their, as far as the owners are concerned, alleged breach is putting owners at the risk of being in breach under the contract of carriage. So owners' rights should continue to be reserved. One of the first things that an owner should do in such circumstances would be to take local advice and see if in this exotic jurisdiction a lien could be properly and lawfully effected on the cargo. And we have seen various interesting advices from local lawyers where, for example, we're told that it is not possible to effect a lien if the charter does not own the cargo, which they sometimes do, but most of the time they do not. Or that a lien may not be possible if the bills of lading, if no bills of lading have been issued. And we have been in this situation. And we took the initiative to resolve that, and thankfully we did, by originally asking the charterers to issue bills of lading. And then when they refused, we went on and issued them ourselves under implied authority under the charter party that stated that a charter is to present a bill of lading and the master is to sign it, etc. So after taking the advice and depending on whether a lien is possible to be effected on the cargo, an owner may take the vessel as close as they can to the port, but staying out of territorial waters or port limits, depending on what they're advised in terms of their ability to effect a lien, or the vessel could drift nearby or happen to sustain a mechanical failure so that the owners can get a bit more time. At the same time, it's always advised that the owners should send notices of lien, notices of freight and hire intercept to all the parties in the chain, their brokers, everybody, so that they can potentially be paid through that. Of course, there's a risk that bills of lading may be marked freight prepaid, but that doesn't matter because what matters is if freight has actually been paid. And there's the added difficulty also of a third party. I mean, I have never, to be honest, I've never seen a third party simply paying because they got a notice of freight intercept or hire intercept. The prudent thing to do for a party would be not to pay, but to pay in court, to pay this money in court and interplead and basically say, right, I've discharged my obligation, I've paid the money into court, now you figure out who needs to take this money. This impasse will obviously bring some pressure on the charters as well, because they may have other contractual obligations, either under a subcharter or under a COA, a contract of affreightment, as well as other potential contractual obligations. Following an impasse, usually things get usually a solution is found either by payment of monies into escrow or otherwise, and it's always prudent for an owner to obtain a letter of indemnity from the charter, provided of course that the charter is worth their powder and shot. Otherwise it would be not worth the paper it's written on. Of course, the receivers at the discharge port should also be I'm going to respond very quickly, very shortly, Alexandros, on your question. Yes, the receivers should be contacted and potentially they could provide a letter of undertaking that they will not arrest the vessel. At the same time, owners should seek ship owners liability cover, SOL cover, to take care of potential difficulties in terms of liability they may face. And things can be time sensitive, particularly if a cargo is perishable. So going to the question of Alexandros Patakos, the question is, can someone exercise a lien on cargo even on freight prepaid bills? Well, there's the simple answer and there's a complicated answer. If freight has been paid, then the answer is no, but they can always try it. And the practical approach to this is that by the time it is figured out if freight has indeed been paid under these bills of lading, then this time could be enough for a solution to be found. But I take the point that an owner would give up their lien contractually if they have been paid the freight. So, in conclusion, there's only a couple of things that spring to mind when it comes to dealing with situations like that, and these are the cases we love, the live cases where decisions have to be made now. One needs to react quickly, but do not rush. And one needs to seek legal advice, whether it is from their club or lawyers immediately. So hopefully this case study, albeit a theoretical one, gave you some insights into how to deal with live situations where a number of stakeholders are involved and a number of conflicting interests are involved. So this is all, if we can have the next slide, please. So this is Evelyn and I. Evelyn's photograph was taken shortly after I told her she was wrong on a point. Feel free to drop us a line on any questions you may have. We're always available to assist, even on the telephone, and always happy to discuss any issues. And thanks again to the West for having us here and inviting us to co-present. And over to you, Ian, I believe.
Yes, indeed. Well, I didn't see that there were any more questions coming up, but of course, as Dimitris and Evelyn have mentioned, you're very welcome to contact either them or us at the club if you do have any questions that arise out of this, and we'll do our very best to answer them for you. I do make a small apology almost for the fact that we mostly come from an owner's perspective. We have a large chartering membership within the club, but of course it's a question of poacher turned gamekeeper, and we very often get involved in a lot of these sort of knotty questions from our charterer's perspective as well as the owners. So it's just the other side of the coin, and it's particularly difficult as well, where if you're working for a charterer member who is the charterer in the middle of a chain, and these types of events are starting to move up and down that chain, and particularly where there's a mismatch in charter party terms, it can be quite difficult to try and find your way through these things, and it's a challenging path. So the presentation will be available on the website, and I'm grateful to Tom Kemsley for sorting out the IT side of this, because there is not a possibility I will be able to do it. There will also be the recording of the video as well on there for anybody. So it remains for me to thank Dimitris and Evelyn and our friends at Thomas Cooper, or now Penningtons Manches Cooper.
We sometimes get confused ourselves and call ourselves Thomas Cooper, indeed.
To say thank you very much for all of the work that you've put into this. It's been greatly appreciated. These are not necessarily straightforward issues, and I think you've steered a very clear line through them. And it also remains me to thank everybody for joining us, and to wish you a very good evening, and look forward to you joining us again soon for further webinars that the West has got in the pipeline. So thank you again.
Thank you very much.
Thanks.